Good morning, everyone. My name is Yuen, and I am from the National University of Singapore's Environmental Law Students Association, which is supported by the Asia Pacific Centre for Environmental Law. I am a rising third year LLB student. My presentation will be on the role of civil society in environmental law and policy in Southeast Asia. Civil society groups have been increasingly involved in the making and implementation of law and policy. My presentation will explain the reasons for civil society's success and the importance of civil society, as well as highlight the key success stories in the region. There are a number of reasons for the rise of civil society in environmental issues. Southeast Asian countries are moving away from authoritarian regimes and are undergoing democratization. Rapid economic growth and export-oriented economies have also contributed to income inequality between urban and rural areas. Civil society, thus, is beginning to play a role in organizing grassroots awareness of and resistance to centrally planned and executed development projects. In more developed countries, there is an increased awareness of the importance of the environment. The importance of public participation is undeniable. Civil society may perform 5 major roles in environmental governance. Firstly, they can collect, disseminate, and analyze information. This provides technical support for governments and businesses to work together to develop solutions to specific environmental and social problems. Secondly, they can provide input to agenda setting and policy development processes. This independent source of creative intellectual input and visionary thinking provides an important channel for the development of strategic rather than reactive approaches to development challenges. Thirdly, they can perform operational functions. They can provide direct services to those affected by environmental changes. Beyond providing for the people's basic needs and public goods, they can also conduct activities for capacity building and community empowerment. Fourth, they can assess environmental conditions and monitor compliance with environmental agreements. This ensures that the government is held accountable and will be kept in check to perform its duties. Fifth, they can advocate for environmental justice. They can help to bring issues to the public spotlight and change social norms. Ultimately, public participation contributes toward fair processes and fair outcomes, as different stakeholders can express their concerns to allow for a more calibrated approach in aligning and balancing competing interests. Important in a number of international and regional documents, which also outline the ways to make public participation effective. Although the Stockholm Declaration in 1972 did not mention public participation, it did recognize in Principle 19 that the public had to be educated about environmental issues to broaden the basis for an enlightened opinion and responsible conduct by individuals, enterprises, and communities in protecting and improving the environment in its full human dimension. The Earth Summit at Rio de Janeiro in 1992 first proclaimed the principles of public participation and elaborated on these in a detailed action plan for the Earth called Agenda 21. The Rio Declaration called for access to information and judicial and administrative proceedings and the facilitation of public participation. The Agenda 21 recognized the role of major groups in the world that had hitherto been passive, such as farmers, NGOs, youth, and scientific and technological communities. The ASEAN Agreement on the Conservation of Nature and Natural Resources in 1992 is unfortunately not in force, as 3 ASEAN countries have not ratified it. Nevertheless, its drafting is a sign of progress in solutions of environmental issues. Article 16 promotes education and the circulation of information and the organization of participation of the public in the planning and implementation of conservation measures. Other ASEAN documents are the ASEAN Strategic Plan of Action on the Environment for 1994 to 1998, following the Real Earth Summit in 1992. Strategy 9 promotes regional activities that strengthen the roles of major groups in sustainable development. Propelling the ASEAN Vision 2020, there are also calls for states to enhance public information and education in awareness of and participation in environmental and sustainable development areas. Aarhus Convention grants the public rights regarding access to information, public participation, and access to justice in governmental decision-making processes on matters concerning the local, national, and transboundary environment. It focuses on interactions between the public and the public authorities. It is a means to enhance the environmental governance network. Mechanisms are created to empower public participation in the decision-making process and guarantee access to justice. There is governance by disclosure that leads a shift towards environmentally responsible society and a reactive and trustworthy relationship between civil society and governments. However, it has only been ratified by European and Central Asian states. Guidelines for the development of national legislation on access to information, public participation, and access to justice in environmental matters, or otherwise known as the Bali Guidelines, were adopted by the Governing Council of the United Nations Environment Programme in 2010. It lists down guidelines for the access to information, collection of information, dissemination of information, reasons for decisions, and access to justice. There have been a number of success stories in environmental movements in the Southeast Asian region as a result of civil society efforts. They have contributed to environmental impact assessments informally and formally, and national and international laws through lobbying and law enforcement mechanisms. They have called for the carrying out of environmental impact assessments, or EIAs, and in some cases even conducted the EIAs themselves to halt or call for the re-examination of development plans. Most jurisdictions include environmental assessment requirements in the primary legislation and have regulations or guidelines on that. However, there is no such requirement in Singapore, and such a requirement may not be strictly followed in all countries. In 1992, the Singapore government announced that it would be demolishing the Lower Peirce Reservoir to construct two public golf courses. The Nature Society of Singapore conducted their own EIA as the government refused to release the results of a study that they had conducted. They published this EIA, which surfaced problems such as the loss of forested catchment, long-term pollution of the reservoir, and loss of the nature reserve area. This increased public input and public scrutiny of the proposed construction, and eventually, the golf courses were never constructed. The Singapore government announced that it would be reclaiming land over Chek Jawa, an intertidal flat in one of Singapore's islands. The supposed EIA conducted by the Singapore government authorities concluded that the area did not appear to have a resident population of dugongs and did not have any established coral reefs or reef communities. As such, there was no biodiversity worthy of protection. Again, the results of the government study were not publicly available. However, it was an extremely limited scoping study, as a Singaporean biologist later discovered the richness of Chek Jawa's biodiversity that was only exposed during low tide periods. Once the public knew of this information, they became very eager to visit the site, and the number of visitors increased dramatically. Many also wrote to the government to prevent land reclamation from happening on the site. Eventually, the government relented and announced that land reclamation would not take place over Chek Jawa. Unfortunately, Due to the increased number of visitors, the biodiversity in Chek Jawa suffered irreversible damage. The examples of lower piers and Chek Jawa show that environmental assessments conducted by civil society can present different and more useful results, which can then affect public awareness and action, and ultimately influence government decisions. In 2013, the Singapore government announced its plan to construct a mass rapid transit (MRT) cross-island line across the Central Catchment Nature Reserve, even though the reserve was protected from destruction by the law. There was no mention of an EIA. Some nature groups, including the Nature Society of Singapore, expressed their concern and called for discussions with the government. It was only then that the authorities mentioned that an EIA would be conducted and possible mitigations would be looked at. There was, however, no consideration of an alternative route. The Nature Society submitted a position paper on the detrimental impact on natural habitats and biodiversity of the area that the construction of the cross-island line would have, and also proposed alternative routes. EIA reports were then made available online instead of in physical copies after strong public feedback about the inconvenience of having to make appointments to review physical copies of the reports. With the support of international environmental groups, three local native residents in Malaysia lodged High Court action because the project entailed the destruction of their longhouses and ancestral burial sites, as well as land and forests, which provided shelter, livelihood, food, and medicine, to which they claimed to have a strong cultural attachment. The plaintiffs insisted on a right to a copy of the EIA report and to be heard and make representations under the right granted to them by the Environmental Quality Act and all the related subsidiary legislation. Although the appellate court rejected the plaintiff's claim, the plaintiff's action garnered much public attention for the environmental issues involved and raised awareness about the importance of EIAs. In Indonesia, the Indonesian Peasants' Union, or SPI, a national federation of peasant organizations, has carried out advocacy on a proposed food law. To influence this process, SPI invited parliamentarians to a workshop to debate the bill, visited each political party to present concerns and aspirations of SPI members, attended the meetings of the parliamentary committee responsible for discussing the bill, and convened press conferences and public seminars. Attending parliamentary meetings as observers enable SPI to identify those members of parliament that empathize with SPI's perspectives and demands. SPI feels that important parts of the law reflect the concerns of SPI members. For example, the law explicitly refers to the principle of food sovereignty, which is what they fought hard for. Food sovereignty prioritizes democratic control over the production and distribution of food and supports interests of smallholder farmers instead of large agricultural companies. It resists the free market discourse of food security and promotes policies of protectionism and egalitarianism. Civil society organizations have raised concerns about recent legal reforms in Myanmar. The Farmland Law and the Vacant, Fallow and Virgin Lands Management Law, both enacted in 2012, contain mechanisms for the recognition of individual and customary use rights. Yet, the legislation confirms the government's ultimate ownership of all land. Important provisions remain vague, and there are limited options to challenge decisions taken by the new Farmland Administration Board, which is the authority responsible for issuing land use certificates. Civil society groups are still pushing for clearer rules regarding farmers' use rights, an independent dispute resolution mechanism in relation to leases of vacant, fallow and virgin lands, and the application of free, prior and informed consent as a condition for such leases, amongst other things. While Civil society has attempted to provide input for land laws, though their efforts have not been successful. Formal public consultations on the drafting of laws often offer important opportunities for civil society to formulate proposals for reforms that would strengthen local land rights and improve accountability. However, even in the case of extensive collaboration between civil society organizations, expert lawyers, and ministries in the development of drafts, legislation may be adopted that does not take into account of citizens' concerns. There are few guarantees that the resulting law will incorporate CSO proposals. The relatively extensive dialogue on a new land law in Laos, for example, is not generating confidence that policy or practice will be reoriented in the way some civil society and development partners are proposing. Provision for enforcement of environmental legislation by members of civil society is limited, with only Indonesia, the Philippines, and Timor-Leste including specific provisions to bring environmental-related actions in the courts. Philippines and Indonesia have experienced an increase in environmental litigation in recent years, though with regard to Indonesia, the floodgates are less open. Philippines has seen some vigorous and innovative public interest litigation to ensure the upholding of constitutional rights. The most well-known case is Oposa against Victorian, 1993, where the plaintiffs who were minors had a clear and constitutional right to a balanced and healthful ecology and were entitled to protection by the state in its capacity as parents patriae. The twin principles of intergenerational justice and intergenerational responsibility were recognized. There are additional advantages in using a human rights approach to environmental protection compared to an approach based on tort law or bureaucratic regulation. The human rights approach may also stimulate concomitant political activism on environmental issues. Concerned citizens and NGOs are more likely to rally around general statements of right than a highly technical, bureaucratic regulation expressed in legalese. In Indonesia, communities and government officials are working together to bring more lawsuits and have been successful in a number of cases that have been brought. For example, the Indonesian Supreme Court in 2015 ordered palm oil company PT Kalista Alam to pay a record amount of $26 million in fines and reparations for its cut and burn practices in the Tripa peat swamp region. However, lawyers and advocates face difficulties in meeting strict evidentiary requirements to establish where the burning is occurring, who is responsible, and the causal link between burning and health problems in affected communities. In one case, satellite images were not accepted as evidence. Judges and even witnesses may hesitate to impute causality or link the health impacts to the haze, even when there is scientific basis to support it. In 2014, a number of NGOs in the region had jointly brought a complaint to the Organization for Economic Cooperation and Development (OECD) regarding the construction of the Xayaburi Dam. The dam will block critical fish migration routes for between 23 to 100 species. It will block the flow of sediments and nutrients, affecting agriculture as far downstream as the Mekong Delta in Vietnam. The Lao government will relocate at least 3,000 people, and more than 202,000 people living near the dam site will be directly affected. The campaign to stop the Xayaburi Dam has garnered worldwide media attention, shining a spotlight on the importance of the Mekong River and the millions of people that depend on it, and creating a space for greater debate about the future of hydropower development in the Mekong River basin. The project has faced significant delays since it was first proposed, and has promoted widespread studies into the rich resources of the Mekong River. Laos announced a halt construction for a period in 2012 due to complaints from neighbors and environmental groups, though construction is now underway. There needs to be an understanding by all involved, especially the government, of the culture and practices of a particular community or people, including their internal decision-making processes. Mechanisms must be available to assist the weaker party to ensure a level negotiating table, and all parties must have recourse to effective mechanisms for redress of grievances. In countries where political freedoms are limited and citizens who speak risk repression, legal empowerment strategies need to be tailored to very specific entry points for influence. Investment in research to develop evidence-based policy messages may be a more effective strategy than open campaigning or court cases. In Vietnam, high levels of respect for academic communities mean that published research can have an impact in policy circles. Where the political space is more open, legal tools are commonly used as a component of wider advocacy strategies, and civil society organizations are pushing the boundaries of law to work more in the interests of rural populations. My hope is that public participation will become more valued by governments in Southeast Asia. Public participation does not always stand in opposition to government issues and can aid the government in understanding the people's needs. Wise governments should try to involve the public as much as possible in their actions. Thailand and the Philippines can take the lead in fostering processes that will bridge the gaps between civil societies in Southeast Asia and to strengthen the civil societies of other countries in the region. A healthy civil society and a pluralist political system offer a stable and secure foundation for participatory and democratic resource governance.